Right.
When you're ready, Robin.
Good evening, everybody who's here and who are here elsewhere. Back in 1967, a senior junior from the Patent Bar retired and went to become a Don at St. Peter's College, Oxford. Of course, they didn't teach intellectual property at St. Peter's. But he had the idea that something could be done, and he persuaded a Japanese company to donate some money for a library. He didn't get IP going in Oxford, and he was very sort of private person, and there were only 2 keys to the library. One was held by the porter, and he had the other. When I was quite a new judge, I got a letter from a man called John Barron, a classicist from this great university, who had taken up the mastership of St. Peter's. Would I have lunch with him? He wanted to discuss something. So he took me to the Reform Club and told me about this library and wanted to know whether it would be a good idea to do something with intellectual property. Would I come and see the library? He arranged it to be on a day when Peter Hayward was not there, and we could get the key from the porter. And it was a good IP library. And I said, yes, you can do something. And he said, right, we will get intellectual property going in Oxford. And I'll create a chair. And did various clever things. And they then advertised it. And I think I was out on circuit, and a man called Hugh Laddie was on the appointing panel, and that's why we're all here, because he picked David Vaver. David Vaver would not only have been the best candidate, he would have been the best man in the world to do it, and he did it at that level. And he's still firing on all cylinders, and we're going to hear him now.
So thank you, Robin, for that introduction, which I think was just a little over the top even for you. But it's superfluous to say what an honour it is to be invited to give the Sir Hugh Laddie lecture this year, but I'll say it anyway. Thank you for inviting me. I knew Hugh less well than many of you did. As Robin just said, I first encountered him in 1997 in Oxford, when he was a member of the board electing the inaugural chair in intellectual property and information technology at the university. He was one of 2 electors associated with the University of Cambridge who came to make sure no one too clever got elected at Oxford, and that they certainly succeeded, at least then. It would take a doctoral dissertation to do justice to Hugh's enormous legal contributions in his 25 years at the bar and 10 on the bench across the whole field of intellectual property law, which I'll now abbreviate mercifully to IP. I can touch on just a few. Most are well known to IP lawyers everywhere, so for some this may be a trip down memory lane. A good or not so good trip, depending on how your case came out. For me, it was a trip through the judgments of a master craftsman who could succinctly summarize the dispute before him, weigh the conflicting evidence, say what rang true and what did not, state the applicable law, often from first principles set in their historical and policy context, and end by saying who won and lost and what to do. IP gives its holders the right to interfere with other people's business activities. So what judges, as the system's ultimate gatekeepers allow or disallow can seriously affect the public interest and the economy, let alone the parties to a case. Given that, one can only marvel at the amazing speed with which Hugh's judgments came down. Amazing, at least to an academic who spends the morning composing a sentence and the afternoon deleting it. The trip was also a reminder of how persuasive Hugh's writings remain, even where their statutory underpinnings may since have changed. There are limits on what first instance judges can do to develop the law, but Hugh had no qualms in testing them. His success is proved by how much courts and treatise writers here and beyond rely on his decisions. A teaching casebook could easily be constructed on the back of Laddie's leading IP cases. Of course, Hugh was not infallible. That's reserved for Supreme Court judges, at least in the majority. Still, Hugh's batting average in appeals and approvals is enviable. He wrote with a close eye to his audience. Judgments, of course, speak to many constituencies: lawyers, other courts, treatise writers, students, the public, but as importantly, to the losing party. Hugh did say, in a case on whether trademarks were confusing, that the solution was more, quote, feel than science, unquote. But judicial feelings require explanation, and not just because appeal judges may tell you off otherwise. The losing party has to know clearly why the judge felt as he or she did. The explanation may need extensive chapter and verse, so an edited version of one of Hugh's judgments, delivered 8 weeks after the hearing of a case that had run as long, takes up 130 pages and 2 parts of the law reports. Nor will the explanation always be welcome. Certainly wasn't for a claimant Hugh called, quote, amongst the most dishonest of witnesses or litigants I have ever seen, unquote. That rested on more than a feeling, as Hugh's judgment demonstrates in spades. Otherwise, he rarely said in a page what could be said in a sentence. Not always common in a profession where said spade may appear in a patent as a digging device comprising a blade member and a platform member for transporting material between locations. Such qualities are exemplified in a case of Hugh's from 1997. The American Elvis Presley merchandising monopoly had come to England seeking to register Elvis as a trademark. The plan was to litigate an unlicensed merchant selling Elvis memorabilia out of the UK market, as they had done in the US. But the Americans came too late. The merchant had beaten them to the UK registry with his own Elvis registration. Hugh knew that in the US, film companies often held merchandising rights in their movie characters, and celebrities and their estates often held rights over commercial uses of their name and attributes. In some states, if you want to change career and become an Elvis impersonator, the Elvis merchandising company will want a cut of your take. So a good part of Hugh's judgment, refusing registration, was devoted to explaining that English law recognized no such rights. Names and attributes were free for the taking or registering for a business if there was no passing off. The Americans had no monopoly on Elvis or Elvis Presley. As Hugh put it in a much quoted passage, there is nothing akin to copyright in a name. Even if Elvis Presley was still alive, he would not be entitled to stop a fan from naming his son, his dog or goldfish, his car or his house, Elvis or Elvis Presley. The Americans fared no better on appeal and flew back to Memphis, markless and no doubt all shook up. Hugh had views on what IP should be and do, and what it shouldn't. It was as Professor Laddie that he set them out systematically in his inaugural lecture here 15 years ago. For him, competition and free trade were the rule, IP the exception. But IP could be, and often was, a good exception. Products and services might cost more, but IP helped clamp down on deceptive trading and helped bring to market what, quote, otherwise would not exist or would take many more years to reach it. But exceptions may have their own exceptions, and the title to Hugh's lecture signals what he thought they were for IP: the insatiable appetite for intellectual property rights. The lecture's subheadings presented more clues: trademark addiction, excessive copyright, the gradual expansion of the patent net. Too much of a good thing can turn bad, and so it was with IP. Hugh nonetheless always distinguished between what he thought the law should be and what it in fact was. Copyright might be, as he called it, overstrong, as he said in a 1996 lecture, but when he had to decide whether a TV documentary critical of checkbook journalism could freely use another channel's footage to make its point, Hugh said his job was to interpret, not supplement the law. Courts had no, quote, general wide discretion to refuse to enforce copyright where they believed such refusal to be fair and reasonable. Ironically, the Court of Appeal thought Hugh himself had been overstrong in the protection he'd given the copyright holder, and held that the documentary could benefit from a fair dealing exception Hugh had denied it. 4 strands to Hugh's thinking are worth noting before we look at further typical examples of his work. First, he thought there was nothing special about IP statutes that required them to be interpreted differently from other legislation. History and context were of course important, but the meaning of common words should not be pressed, quote, far beyond what ordinary members of the public would give them. Judges had sometimes strained IP, quote, with almost evangelical fervour, unquote, to catch behaviour they thought little better than theft. Hugh would have none of it, and later courts have sided with him. Second, IP legislation, for all its imperfections, should be looked at wherever possible as a whole, as a joined-up scheme that extends different benefits for different activities. Exhausting, or not quite qualifying for one kind of benefit, gives you no passport to another kind. Hugh emphasized this feature both as an advocate and a judge. He had, in the 1980s, appeared for the Registrar of Trademarks to argue successfully against Coca-Cola's attempts to register its distinctive bottle as a trademark to get what every trader craves, potentially perpetual protection. The bottle wasn't art, except perhaps to Andy Warhol. It had nothing patentable about it, and the registration for its design, though new in 1925, had expired in 1940. Trademark law does not rush in where IP fears to tread. The Coca-Cola case was brought under the old Trademarks Act of 1938, but Hugh thought the 1994 Act hadn't changed things much. A bottle might now technically qualify as a trademark, but only if the public recognized it as such. They didn't. In the case before Hugh of a yogurt bottle, they relied instead on the container's labels and word marks to differentiate the product source. Third, Hugh was unafraid to take on precedents he thought were misguided. His greatest provocation was undoubtedly the Arsenal case, where he thumbed his nose at the European Court of Justice's intrusion on his authority as a national judge to decide the facts of a case. That didn't end well. When the Court of Appeal said the European Court hadn't really differed from Hugh on the facts, they had just made an, quote, inevitable, unquote, finding of fact that Hugh hadn't. How an inevitable finding of fact is not a finding of fact must have puzzled Hugh, as it puzzles me. Hugh's second greatest provocation was the House of Lords' 1975 decision in American Cyanamid and Ethicon, that to qualify for a pre-trial injunction, claimants need show only, quote, a serious question to be tried. That is, a non-frivolous or vexatious case, before one went on to ask on a balance of convenience whether the claimant would be hurt more if the suspect weren't stopped, and the suspect would be hurt if they were. That approach might work for a case like cyanamid itself, on whether a patent for surgical sutures made from some polysyllabic plastic was unobvious and infringed by a different, equally polysyllabic plastic. Reams of conflicting evidence and argument occupied a patents judge for 3 hearing days and 3 Court of Appeal judge for 8 more, merely to decide whether a company that had not even started marketing should have to wait until after the trial to see if it could. Hugh had no problem with the result, but he did with the test, which made little sense to him for the vast range of simpler cases. It was both wrong historically and positively unjust and inconvenient, if applied generally. Other judges thought so too, I understand. But it was left to Hugh to go on the attack, as he did on the Series 5, in the Series 5 software case in 1995. Judges, he said, were paying lip service to cyanamide while in practice applying different criteria. Claimants should usually show a prima facie case rather than one that merely transcended the risible. In short, who's most likely to win? Otherwise, getting injunctions becomes too easy. Better allow judges to tell the parties how the case then looked and thus encourage quicker settlements to everyone's benefit. So, Hugh rejigged cyanamide's criteria to give judges more discretion and flexibility and applied that approach in later cases, although usually being wily enough to mutter the magic words cyanamide just in case. Some thought Hugh's reformulation heretical, quote. Others said it usefully reminded judges to do the best they could for the moment rather than running a mini-trial on disputed facts or law. Academic writers generally agreed with Hugh. I guess for practitioners that would show why Hugh was wrong. And the Supreme Court of India also weighed in on his side. And in a Privy Council appeal too, the court, through Lord Hoffman, also read cyanamide along lines that would have given Hugh much satisfaction. The Series 5 case still quietly ticks away, biding its time, until perhaps someone recognizes that it deals better than cyanamide with the factors the current civil procedure rules deem relevant to the overriding objective that cases be dealt with justly and at proportionate cost. The last strand I'll mention is the influence on Hugh of a trio of more or less familiar maxims. First, urbi jus, ibi remedium. If someone's got a right, do something about it. Sounds better in Latin. Second, bonus non malus, equitas subvenit. In equity, good folk win, bad folk lose. Decisions are easy where these two maxims coincide. The third maxim is really a warning. Divibus non semper curat lex. Deep pockets shouldn't always prevail. Hugh knew that litigation is often warfare waged by other means, but he did not want the law, and by extension its agents, to become an instrument of oppression, especially where someone of big standing and deep pocket, those are all quotes, is set against someone with less of either. That, of course, doesn't mean that having no money makes you right, any more than having plenty doesn't. The quote about oppression, which I just made, comes from a case with which Hugh's name is inextricably linked. If we time travel back to 1969, when Hugh first came to the bar, we find things were not so easy for claimants whose rights were being infringed, including IP owners. They might get what they wanted at an eventual trial, but getting something done beforehand was tough. If they knew someone was infringing but couldn't find whom, they couldn't make anyone else who did know tell them the culprit's name and whereabouts. If they did track the culprit down and said stop, the evidence would often disappear to the dulcet tones of who, me, Gov? If claimants did get the evidence, they could spend ages in court trying to halt the activity before trial, but win or lose, they'd have to repeat the whole process and more to get a permanent injunction and compensation. Meanwhile, infringers could hide their money offshore and make any judgment against them worthless. All that was changed by a quartet of decisions handed down between 1972 and 1975. The IP bar was responsible for 3 of them. The case names, Norwich Pharmacal, Mariva, Anton Pillar, and of course American Cyanamide, are as familiar to lawyers as aspirant is to everyone else, and give similar relief. Together, they produced a procedural revolution that made life harder for scofflaws and those whose attitude towards doing business legally verged on the cavalier. Hugh was key to this movement, and this just 5 years out as a barrister. Film and record companies couldn't figure out how to stop what they called pirates. These were mainly onshore and didn't have parrots on their shoulder, from illegally copying or selling their goods all over the UK. Hugh invented a novel and non-obvious solution for them: neat, plausible, and right. In 1974, he persuaded 4 different judges to make orders in private without notice that operated much like search warrants, entitling raids on premises where offending stock and incriminating evidence were located. The practice started spreading, including in a case passed to Hugh, where a company's trade secrets were being clandestinely hawked around its rivals. The company was a German one called Anton Piller, still going strong, by the way. When a judge wouldn't give Hugh the order he wanted, off he went, post-haste to the Court of Appeal, and got it there instead. Lord Denning, presiding, recognised that they were doing something, quote, of a kind not known before. Here's a one-off for him, but generously credited Hugh with the innovation. Pillar pushing and handling pillar cases that misfired became handy sidelines for Hugh and kept coming to him after he'd gone to the bench. The orders are now so familiar that it's easy to forget their extraordinary genesis and trajectory. Hugh had made bricks from the straw of 3 not particularly promising 19th century precedents he had located: 2 English, 1 Irish. Only one had anything to do with IP. That was the first, from around the time of the birth of the future Queen Victoria. Well, no, it wasn't. This is not the first. The first one was from this period, not an IP case, but had the House of Lords confirming an order, unlike Pillar, made on notice and hotly contested, allowing independent valuers to enter the East India Company's warehouses in London to assess their rental value, so that St. Botolph's Church in Aldgate could get tithes from its reluctant parishioner. Just quite odd, because St. Botolph was the patron saint of travellers, and you would have thought the East India Company would want to keep in with his good graces. Anyway, the 2 other straws were from later in the century. They were inspection orders that, like Pillar, had been granted without notice. One did deal with IP. It allowed Hennessy's to enter a warehouse that was thought to contain fake brandy carrying its trademark. The other was about unintellectual property, namely wood. It allowed inspection of a ship that was about to depart with a load of timber the claimant said belonged to him. These were pretty thin straws. The reasons in one comprised just a couple of sentences. The other recorded no reasons at all, but at least it had been heard by 4, albeit apparently taciturn, judges. Hugh's genius was to build a pillar from these straws, aided by his 3 maxims. His claimants' undoubted rights needed a remedy. Sure, they had deep pockets, but still they were the good folk, especially when compared to the artful dodgers. Pillar popping made many trials redundant. It was amazing how having one's goods and papers seized and one's assets frozen concentrated the mind. Orders started being granted daily in all sorts of cases, not just IP, and the idea quickly emigrated far and wide. But there were costs. Deep pockets did start deciding cases. An exceptional procedure became routine, and with routine came abuse. Posses turned up at private homes scaring youngsters. Some searchers were bullies, some were slack, still others misled defendants about their rights and didn't give them enough time to contact their lawyer. Judges became annoyed, causing Hugh to team up with Professor Martin Dockery in 1990 to proclaim that something had gone terribly wrong. a procedure meant to prevent irreparable harm to claimants, was causing irreparable harm to their, and this is Hugh's word, victims. They recommended reform, and as we know, the result was a practice direction in 1994, standardizing the procedure, followed by legislation and civil procedure rules regulating what was now called a search order. Similar reforms happened elsewhere too, and the procedure is now kept under constant review to ensure it stays current and non-abusive. I'd like now to look at Hugh's work in some specific areas. Let's start with trademarks and passing off. The appearance of the word brand in pride of place in the name of the Institute for Brand and Innovation Law that Hugh founded here indicates the importance he placed on trademarks in enhancing commerce and consumer welfare, but subject to limits on what could be protected and how far. As the Coca-Cola and yogurt bottle cases indicate, trademark law is not a form of IP meta protection, and yet it has stepped in to prevent parallel imports into the UK and to become part of the arsenal of rights available to a certain football team, or indeed any sports team, to control the sale of merchandise bearing the team's insignia and colours, even where buyers know that they're not getting official gear or don't care. Lord Hoffman dealt with Hugh's contretemps with the European Court of Justice on such matters in the first Laddie lecture. He showed how unimpressed Hugh was with the way UK law, mandated by European law, had expanded the protection trademark owners got in ways that harmed honest competition. We might have expected Hugh to produce a sequel to his Stephen Stewart lecture called Trademarks instead of Copyright, Overstrength, Overregulated, Overrated, and probably without the question mark at the end of that sentence. Hugh's trademark decisions naturally support honest practices and oppose deceptive or misleading ones where possible. Thus, he was against interfering with fair comparative advertising, but for allowing honest concurrent use before it finally was accepted under the 1994 Act as a defence to infringement. But smart alecks, such as those who registered a raft of companies under names such as Virgin, Nike, Armani, Cantona, etc., got short shrift from Hugh, who called them scammers and stopped them cold. An ex-distributor selling new and improved baby bottles under a trademark imitating his former supplier's mark fared no better, nor did newly formed bands who tried to make off with the name of their predecessors. This, the breakaway members of the heavy metal band Saxon learned when they tried to hijack the name by registering a trademark that they then tried to use against the band's remaining members. Hugh invalidated the registration. He said the Levers would be passing off if they performed as Saxon, and their trademark application had been made in bad faith. The Levers could no doubt use another name they had perhaps more appropriately performed under, son of a bitch. Passing off or confusion may of course occur and be stopped even though a later mark differs from an earlier one in look, line of business or territory, but Hugh was against enlarging the circle of protection yet further by allowing registrations that included business beyond what the mark was going genuinely to be used in. Registering for a category as broad as computer software, where you were only in telecommunications and didn't use it outside that business, was far too wide for him. Litigation continues to swirl around this issue today, while the trademark registry becomes ever more crowded. A few more cases deserve mention. Here's Hugh's first trademark case as a judge, where he indicated how he would be deciding cases under the then new Trademarks Act of 1994 unless told otherwise. A well-heeled US-based restaurant operation had started up a chain of curry houses in London under the name Rajamama, apparently not caring that they might be confused with Wagamama, the noodle bar then still a fledgling, but well-known and popular eatery. This insouciance won no plaudits from Hugh, who found for Wagamama both on its trademark registrations and for passing off. A good number of Wagamama's regulars would likely have muddled the two businesses or names, or might well have been turned off if they arrived expecting the vibe of their old haunt and were presented with a menu of vindaloo and chai instead of ramen and a carrot cleanse. Along similar lines were two variations on Elvis's case, both about passing off. In one, British racing driver Eddie Irvine complained that a radio station was using a doctored photograph of him on its promotional brochures. In the other, the BBC complained that T-shirts were being sold carrying pictures of its Teletubbies. Hugh found for Mr. Irvine, but against the BBC. People seeing the brochures might wrongly think that Mr. Irvine was endorsing the radio station, but people seeing Pinky Winky on a T-shirt wouldn't believe the BBC had started flogging clothing. Might be different now, maybe. They might, however, believe just that of some celebrity in light of the common practice now of their name or attributes being used to market or endorse all sorts of products. And so when Topshop started selling T-shirts featuring a picture of Rihanna without a consent, the court stopped it, relying on Irvine's case. Finally, there was the case where Hugh effectively extended common law protection to unregistered geographical indications. Hugh had made clear in an earlier case that bottling Scotch in bulk and selling it as Welsh whisky was not the greatest idea. A dispute he heard about Swiss chocolate was along similar lines. Cadbury had started a line of chocolate with Swiss Chalet emblazoned on the wrapper, accompanied by a picture of the Matterhorn, and, unsurprisingly, a chalet. Unhappy Swiss chocolate makers sued. Hugh's initial skepticism about their case dissipated, as the evidence showed that in England, Swiss chocolate meant more than chocolate made in Switzerland, although it meant at least that. The term had acquired a following based on on where and how the chocolate was made and who made it. While a perspicacious IP judge might not be fooled on their weekly shop, Hugh accepted that the average chocolate lover's sweet tooth would overcome their powers of observation and discernment and make them pay that little bit more for something they wrongly thought would be like the Swiss chocolate they had come to crave. Yogurt lovers who have been attracted to imitations of Greek yogurt they thought came from Greece when it didn't, or vodka connoisseurs who bought Vodkat not knowing its alcohol was a blend rather than pure vodka, have Hugh partly to thank for paving the way for court decisions banning such mislabeling. Let's turn to copyright. While at the bar, Hugh was involved in cases as varied as whether an ordinary living room sofa could qualify as a work of artistic craftsmanship. Answer, no. But the miscellany of reasons given amounts to little more than, I know a hawk from a handsaw when I see it. Whether a popular thriller novel may take chunks from a book on history to thread through its plot. Answer, no, too much taken. Whether copyright was subject to a common law right of repair. Answer, yes, but the idea has not met universal acclaim. Or whether formats of television shows like today's Strictly or Britain's Next Top Model were protectable by copyright. Answer, no. More fluid ideas than fixed works. Hugh had an equally varied diet of cases as a judge. I'll mention just 4. The first concerned a home decorating magazine that unsuccessfully sued another for allegedly copying its look and feel. Hugh produced a handy primer on how to run or defend a typical copyright infringement case. He warned against protecting mere ideas and common trade elements or being misled by what he called similarity by excision. Chipping away and ignoring all the bits which are undoubtedly not copied may result in the creation of an illusion of copying in what's left. As important was the question of what was actually supposedly copied. Was it the magazine cover as a single work, or did each of its components also have their own copyrights? Hugh rejected the multiple copyrights idea. A cover was not a legal millefeuille with layers of different artistic copyrights. I'm not sure how Hugh would have felt about later developments that let newspaper headlines have copyrights separate from their articles, but his millefeuille image warns against slicing too finely or indiscriminately. If a song comprises layers of copyright in each phrase and bar, musical composition becomes practically impossible without the risk of being found guilty of subconsciously copying one of the myriads of copyrights in some earlier song. I mentioned earlier the case where Hugh decided not to stretch the categories of copyright beyond what they meant in common English. So, for example, sculpture for him denoted a three-dimensional piece of art made by an artist. It could include ephemeral work, such as sandcastles and ice sculptures, but not manufacturing molds used to produce ordinary functional items of commerce. The category's content may also be affected by what the art world would consider a sculpture, a category that may change over time. What Turner thought in the 19th century was art is not what has often won his eponymous prize over recent years. Hugh's views later helped support the view that the stormtrooper helmets in the Star Wars film weren't sculptures. There is no toy helmet category for the Turner Prize. Hugh also had to deal with what counts in law as joint authorship in two niche cases that have affected how collaborations in music, drama, and literature are categorized. The first involved a designer employed by a home builder who had an independent firm of technical drafters translate his rough drawings and concepts into architectural plans for a line of houses. A rival builder was sued for copying the plans for its own line of houses, but said the first builder couldn't sue because the copyright was owned by the drafters who had actually drawn the plans. Hugh disagreed. Authorship was more than pushing a pen or moving a mouse. It lay in the, quote, skill and effort involved in creating, selecting, or gathering together the detailed concepts, data, or emotions conveyed by the words or lines represented, not just in the symbols themselves. If two people work on these tasks together, they may become joint authors and copyright owners, and both or either can enforce their copyright interest. The second case was a similar yet different collaboration. A buyer who had ordered a bespoke computer program was sued by its developer for making multiple copies of the software. The buyer said he was a co-author and so just as entitled to copy it as his co-authoring developer was. The buyer clearly had a major hand in the software's development. He said what he wanted and suggested fixes. But Hugh said his involvement wasn't like the building designers. The buyer wouldn't know how to begin to structure or write a computer program. He was more like an editor or proofreader. You can tell J.K. Rowling what you'd like in a Harry Potter sequel and check her manuscript for spelling, grammar, and plot coherence, but that doesn't get you on the title page as co-author. These cases threw up a recurrent issue for Hugh, possibly the only thing he would have shared with Michael Gove: experts. Churchill was wont to say that there were three types of falsehood: lies, damn lies, and statistics. The jest, in fact, comes from a saying current round Lincoln's Inn in the latter part of the 19th century, and sometimes attributed to Sir George Jessel, that there are three sorts of liar: the liar simple, the damned liar, and the expert witness. Hugh ran into the third category early on. not necessarily outright liars, but rather witnesses who acted more as hired guns than objective seekers after truth. Parties, of course, shop around for the most mellifluous expert to support their case, but still, the expert is there primarily to help the court. Hugh had no difficulty with the honest expert who was doing their best, but any expert who hadn't done their homework would not repeat the experience in Hugh's court. Nor would the one who rashly wrote a paper entitled "The Expert Witness, Partisan with a Conscience," likening expert witnesses to a dealer in three-card Monte, except the mark was the judge. Hugh told him off at length, including the riposte, if litigation is to be conducted as if it were a game of three-card trick, what's wrong with having a couple of aces up your sleeve? Hugh had no time for cock and bull stories at the best of times, but his intolerance with experts who weren't doing their job sometimes got him into trouble. A disgruntled claimant, whose patent Hugh had revoked, appealed, saying Hugh had shown bias when questioning their expert on inconsistencies in his evidence, and ultimately rejecting it. But the Court of Appeal thought the complainant was just another sore loser and supported Hugh. Hugh's conduct may be contrasted usefully with the judge in Chicago a few years ago, who had been to and froing with a defendant charged with income tax fraud, who claimed that the tax system was voluntary and he hadn't signed up for it. The judge finally lost his cool and told the defendant, "This is all complete BS," except he did not abbreviate. "If you keep arguing, I'll kick you out." If Hugh ever harbored such thoughts, he wisely kept them to himself. I think you probably imagine how that case came out on appeal. Finally, let's look at patents. Hugh's patent cases ran the gamut from electronics, genetics, medical, pharmaceutical patents, through to ferry boats, laying underwater cables, tents, motor mowers, gas burners, contact lens, toothbrushes, coffee sweeteners, and so the list goes. Few nooks or crannies do not bear his mark. He provided guidance on patent office procedure, on what is and isn't patentable, when additions to a patent may be made, how to construe claims and specifications, when an invention is anticipated or obvious, what amounts to infringement, when defenses such as good faith prior use are available, and more esoterically whether repairs on a sewer running under the Houses of Parliament should be stopped at the 11th hour because of a possible patent infringement. Unsurprisingly, no, although more because the application came in late rather than public inconvenience was involved. One key area dealt with how much of an infringer's profits should be handed over to a patent holder. The standard story has long been that electing this optional remedy is not usually worth the candle. By the time you've prized the necessary data out of a reluctant defendant and paid accountants to analyze it and come up with a plausible figure, what you recover is often less than what you spent to get it. Hugh's case in 1999 did not entirely negate that story. The parties had started off £176 million apart. The claimant wanted his full $180 million. It said that the infringer had made from using a patented process. The infringer said it owed at best £4 million because the process was just one of many inputs into the finished product. Both parties must have been startled when Hugh awarded a figure some 85% below the infringer's estimate. Hugh's classic judgment on how to apportion infringing gains has nevertheless rekindled interest in the remedy. His name has come up in a case now before the Canadian Supreme Court where a $650 million award is being challenged because of the inclusion of profits from non-infringing activity that the infringer says has doubled what is owed. Whether the Supreme Court will award just 15% of the latter sum remains to be seen, but Hugh's case will undoubtedly figure in its decision. I want to deal with just one patent case. I've chosen one that typifies Hugh's thinking and the application of his three maxims. The case dealt with the law of obviousness, but it had nothing to do with high-tech or recherche science. It's a case that sends a message of hope to all home inventors. Think up something simple and practical, and you can get a patent, even if no complex chemistry or electronics are involved. But if you do come up with a winner, be ready to take on an industry that may think it has a monopoly on good ideas, even when it hasn't. Hugh's judgment reads like a film script along the lines of The Flash of Genius a few years back, where an inventor took on Detroit for stealing his idea for intermittent windscreen wipers, and after much tribulation he won. Here, an inventor called Mandy Haberman got interested in helping infants with feeding difficulties. She saw training cups being used by toddlers who hadn't graduated yet to drinking from a regular cup. But the training cups all leaked. Miss Haberman hit upon the idea of a cup that had a spout with a slit valve like a nipple or teat. The contents would escape only when the spout was sucked. The cup didn't leak or spill, even if it was shaken or turned upside down. I have an audio-visual thing here. That's the Haberman cup. Not a drop of Welsh whiskey was spilt there. Miss Haberman patented it, and the Haberman cup was and remains a hit. I leave to your speculation why the male-dominated makers of infant feeders hadn't themselves thought of the idea. Inevitably, the copycats arrived. The main one revelled in the name of Jackal International. When challenged, it said somewhat patronizingly, "What's inventive about sticking a slitted teat into a spout? It's obvious, the patent's invalid." Miss Haberman sued. The hearing before Hugh took 4 days in early December 1998. Those 4 days didn't go well for the Jackal. It's been said that lone inventors are largely a myth, and if you do find one, it's not because they've made any conscious effort to invent, but usually because they've botched an experiment. Fortunately, reports of Miss Haberman's mythic existence had reached neither her nor Hugh, for he wrote a judgment in her favour over the Christmas break. It contained a mini treatise on the law of obviousness, including a now classic discussion on when a product's commercial success negates obviousness. Hugh said the slit valve was indeed a very small and simple step that anyone in the infant feeder industry could have taken. But they hadn't, despite knowing for years that there was water everywhere and hardly a drop to drink. Hugh said the solution, quote, was there under their very noses, but it took a comparative outsider to see it, unquote. Quite apart from her counsel's powers of advocacy, I think Ms. Haberman was fortunate to have got Hugh as a judge. Another one could easily have found against her, and such findings are notoriously hard to overturn on appeal. The judge may have been a disciple of Judge Henry Friendly, who once remarked, only half in jest, that any invention he could understand had to be unpatentable. Patentability often boils down to a value judgment on which minds may differ. Is the disclosed advance inventive enough to deserve a patent? Or patent law's policy of rewarding and encouraging inventors be furthered or set back by finding for this one. Hugh relied on the commercial success of the Haberman Cup to tip the balance in favour of unobviousness. He was usually sceptical about commercial success as such a factor, and I am too, because it's there in virtually every patent case that is litigated. Who sues to enforce or invalidate a patent on something that's a flop? Obvious innovations are hits too often. Commercial success seems patent law's counterpart to the now discredited, quote, rough practical test, first trotted out a century ago in a copyright case where exam papers emanating from this very university had been copied. The judge there said copyright must exist in them because, quote, what is worth copying is prima facie worth protecting. The test is not just rough, it's no test at all. Yet it still manages to cling on in different garb in patent law. Hugh was, I think, on stronger ground in looking at the industry's history with infant feeders. Before Ms. Haberman came on the scene, no one seemed to have heard of the KISS principle of design. Keep it simple, stupid. Even though leaky cups had been around for ages, earlier attempts at cure seemed inspired by Heath Robinson. The industry was awash in what Hugh called folklore, perceptions, and prejudices, unquote. Had it been the Stone Age, they would still have been there chipping rocks. We've looked at a mere sample of Hugh's work without touching on his major contributions in so many areas simply because of time. In evidence and procedure, managing transnational litigation and conflicts between domestic and EPO proceedings, Euro defences, threats actions, design rights, confidential information and employee mobility, and remedies. I'm sorry if I've missed out one of your favourites. Nor have I collected all his bon mots, although I do particularly enjoy one from when Hugh was at the bar, which Sir Robin quotes in one of his cases. How does one best go about settling disputes? Always try to negotiate with your foot on the other man's neck. Hugh did have a practical side. I'll conclude by repeating the concluding paragraph to Hugh's inaugural lecture. We should be trying to hone the IP system so that the greatest rewards and encouragement go to those people and industries which need and deserve them most. Where IP rights perform their function of advancing the sciences or arts, they should be encouraged to do so. Where, or to the extent that they do not, they have no economic justification, and the normal discipline of competition should prevail. The gluttony which has resulted in the growth of completely unnecessary or excessively long IP rights undermines the system itself. As Shakespeare put it, with eager feeding, food doth choke the feeder. Indeed so. Thank you.
David, I think, will take questions, although I haven't asked him.
Of course.
Will you take questions?
I will take questions, of course.
Very good. Fire away. Must be some. Yes.
How many pieces did you read to find out?
I have a lot of footnotes where I've included them. I will, if you like, I'd read them out. There are 143 footnotes, some of them as long as something that I told people this morning at the PhD conference never to do, running over a page and spilling onto the next page. So I think the answer is certainly in 3 figures, not 4.
Did you ever check to see how many times he was reversed by the Court of Appeal?
I did check. You don't want to know the number. It wasn't all that much. Probably as much as one R. Jacob was reversed by them.
I reversed you.
I know you did, to your eternal shame.
Well, any more questions?
Thank you, David, for a wonderful lecture. I'm Janice Dennicourt from Nottingham Law School, but I'm also director of the IP Awareness Network, where Mandy Haberman is a fellow director. So I'll pass on that you included this case in your speech to her, because she's very much involved in raising awareness even today. And she's currently, I think, working on the Global Win Female Innovators Project. So she's still going strong, her company is thriving. So many thanks to Judge Hugh Laddie and yourself.
Please do pass on my best wishes to Mandy Haberman. She was on a committee I was on many years ago. I didn't choose her case because of that. I chose it because I thought it showed Hugh the man and Hugh the judge.
Excellent, thank you.
Thank you.
Any more? Well,
There's one up the back there, I think.
there's one up there, oh, right in the back. Yes, Luke.
I have a loud voice, so I don't need a I wonder, David, if you wouldn't mind saying a few words about Hugh's textbook while we're on the subject, because although it's now been updated, obviously for many years it was. Thank you. For many years it was still just the 2000 edition, but when I was doing my PhD and finishing it almost a decade, just over a decade later, I was still using it for certain subjects because it was still the best around on certain issues. So I wonder if you wouldn't mind saying a few words on that.
Certainly, and I assume when you say his textbook, you mean his copyrights one, because he did one with patents as well with Anthony Watson. Well, I think it was an absolutely brilliant book. It went where other books had not till then gone. It had a lot of refreshing Laddieisms in it. And if you think that Hugh's judgments are cited enormously overseas in other jurisdictions apart from this one, you should try and look up his casebook and see how often that's cited. A lot throughout the Commonwealth in every court, from the highest to the lowest. So it's still relied on, especially on matters of principle, and that's actually quite startling, because the copyright laws of countries other than Britain, many of them were modelled on the Copyright Act of 1911 and less so on the 1956 Act, but they were. Few on the 1988 Act. But so it remains, and this is the point that I made early on, it remains exceptional how much Hugh has relied on, even with the infrastructure, the technical infrastructure of the law that he was talking about has shifted. In other words, he was talking about matters of general principle and policy, which rarely shift all that much in copyright law, although they changed according to technology and, of course, the whims of occasional wacky judges in various jurisdictions who misinterpret the law. But that apart, Hugh's book remains a constant well beyond this country.
I've got a question too. How far is the internet changing all of this stuff?
How far has the internet changed the law?
Well, changing these ideas, and did Mr. Laddie have some views on what was going on with the internet?
Well, I think that's an enormous question, even though it was succinctly put. Technology just does make you what may have been a footnote to something turn into a chapter, and that's true of the internet in many ways. I mean, the law relating to public telecommunication and the law relating to online service providers and all that. There are analogies, but they're not perfect. So yes, it has changed a lot. It's changed a lot in copyright. It's changed considerably in trademarks as well with the online commerce. Still, as I keep coming back, the basic principles have not changed all that much. If someone is using your work and is sort of reproducing it in some form or another, or expanding distribution of it without your consent, well, you know, that sounds a little bit like infringement, and in principle, you're making use of somebody's work. You should be coughing up for it unless there's a user right or defense there for you. And I think that type of principle runs across the whole area, adapted according to the technology.
Yes, one here.
Hello, I'm Simon Newman, University of Westminster. The one time that I spoke with Sir Hugh Laddie back in about the mid-90s, I asked him, did he take account of the public interest in deciding between the parties? And he said firmly, no, he did not. I wanted to ask you, do you think, given everything that you've said tonight, do you think he was telling the truth?
Well, you know, it depends what you mean by public interest. Hugh was not going to, when the statute said X, Hugh was not going to say Y. No judge is going to last under those sorts of conditions. If they keep saying Y long enough, somebody will tell them it's time for them to, you know, buzz off. But the public interest in a larger sense, I think yes. If we come to looking, for example, on the American Cyanamid, his view of the public interest was quite different from what Lord Diplock thought it was. And he gave it different emphases. And he was dealing with a statute which said what was just and convenient to be done, right? When you've got language like that, then yes, of course you're entitled to a greater freedom than if the statute says something a great deal more specific. You're not using weasel words like justice and convenience. So I do think he did take that into account. And I think, quite frankly, I'll stick my neck out here, even though Robin can jump on it or stand on it, as you would say, if I'm wrong. Judges do look at merits of a case quite apart from its technicalities. I think they see if there is a good person there and a crook on the other side. They won't lean over too heavily in favour of the crook. I mean, that's, if they do, and maybe they're in the wrong job. I put it in Latin. I thought I had it better in Latin. Bonus non malus equitas subvenit.
Thank you. Thank you for the wonderful lecture, Dave. If Sir Hugh were alive today, what view would he have on AI authorship? I know there isn't a current case before any court, not to my knowledge, but if it were something he was writing in a textbook, for example, what do you think his views might have been?
Well, I think as a matter of law, I think he would say AI is not an author. It's certainly in the current technology. If someone put in the PhD conference this morning, if animals aren't authors, why would you give the inanimate a shot where they don't? You know, you have copyright tied very much still to somebody's life plus a term. You have requirements for transfer and assignment and licensing requiring signing by somebody. And the Berne Convention is tied to authors. So I think if you are asking as a matter of law what he would have done, I think he would have said, no, it ain't an author. Now, what he would say if you say, well, what should the position be? I think that would be a different case. I think you would say this is something that the legislature should certainly look at, especially the more AI started taking on human characteristics. I don't think it's anywhere near that now, but there's no harm in looking now and seeing what future developments are going to be and making an educated guess as to how you should regulate for them. So I think he would have those, that would be my guess, reading his judgments and his books.
Yep, on over here now. Run, Josh.
Another very simple question. Post-COVID, post-Brexit, do you think he would have advocated a rationalisation of the law to simplify things for non-IP experts?
Sorry, I didn't catch the last bit.
To simplify the law, which is notoriously complicated for general, everyday people to understand?
Yes, no, I think that's a very good question. You know, he was, I think, pretty well furious at the 1988 Copyright and Designs Act, which ran over, I don't know, near 300 sections and 14 schedules or something at the end, from the 1911 Copyright Act, which was, I think, 2 little schedules and less than 40 sections. And he said, well, you know, the technology has changed, but it hasn't changed to the extent that we have to sort of create this bloated monster, which, moreover, at one point says, even though we've changed the language here, we didn't actually intend to change the law. I mean, there's actually a section which reads like that. You say, well, you took a damn long way to say that. And Hugh was, I think, in favour of succinctness. Now, we have so many, where do we start with that question in many ways? I think copyright, yes, should be reduced to principle. It should be made a lot easier. It won't make decision-making any easier. We're still going to get the tough decisions, whatever law you're going to have. But I firmly believe that, and I think Hugh did too, that a law that is designed for authors and artists should be capable of being read and understood by authors and artists. A law which is designed to be designed for inventors should be capable of being read and understood by an inventor. I don't think we're there anywhere near that, but that's the goal one I think should be strived for, and I say nothing about the Trademarks Act 1994, of which the words breakfast of a dog, which certainly describe it.
Right, well, I reckon the magic hour has arrived when we're all going to cross the road and go to either the north or the south cloister, but you'll figure it out by where the drinks are. Yes, but Michael's going to say,
Thank you very much for a wonderful synthesis of Hugh's wonderful life. Thank you. Can I just, you rightly concentrated or mentioned Mandy Haberman's case.
I know you have a particular interest in that one.
I have an interest in that case. But the precedent, the moment before the invention was made, may interest some of the people here. Mrs. Haberman had bought a beautiful, and she told me, a very expensive, knotted white carpet, and invited her grandchild to tea that afternoon that it was installed, and gave the grandchild an ordinary little cup of Ribena. I think you can tell what the rest of the story is.
Yes.
Hugh said, "So, Mrs. Haberman, necessity is the mother of invention." "Quite right, Judge," he said.
there's one other story I can tell about that too. When she made the invention, they had a prototype made, but they had no money. How are you going to get it marketed? and I think it was her husband who had the idea, they took a shoebox. They filled one of these with Ribena, put it in the shoebox with a letter saying, if this has leaked, we've shot ourselves in the foot, and posted it to the chief buyer of Tesco.
That's great.
Wonderful story. No other branch of law gives so much fun to everybody as IP. Come on, over for drinks, everybody. Thank you, David, very much indeed.
Thank you. Thank you.